Hi everybody, welcome to another episode of Foreclosure Help 777 where we talk about everything foreclosure related. And if you're in foreclosure or about to go into foreclosure or you need help with your foreclosure, you can always send me an email. My email address is the number 4, foreclosurehelp777@gmail.com. Today we're going to talk about something that a lot of people don't really have to worry about, but some people do in foreclosure, and that's having to appear in court in front of a judge and do what's called an oral argument. So we're going to talk about oral arguments today, and this should be very useful for some of us that might have to go in front of a judge and do an oral argument. So let's explore that, what that's like. I made a little presentation for y'all. It's called Foreclosure Defense Workshop, Mastering Oral Arguments. And basically the theme is how to prepare, present, and perform effectively at a hearing. Understanding the purpose of an oral argument, what a hearing is and isn't. It's not a full trial. It's a chance to clarify legal issues. When oral arguments happen, motions to dismiss, summary judgment, injunctions, etc. The judge's role, how they use this time to test each side's reasoning. Preparation is everything in this. Review your filings and know your strongest points. Anticipate what the other side will argue. Prepare a short written script or outline that's 1 to 2 minutes max. Practice aloud, especially key transitions and case names. Professional demeanor. Dress like you belong in that courtroom. Men wear a gray suit with a white shirt and a black tie, and women a suit, preferably gray as well, and a skirt. That looks like business professional look, guys. Like you're going to a job interview. You want to really look good because the other side, the attorneys for the bank, will look good, and you want to look equally as good. That's the first thing the judge will look at, is how you look. So that's real important. Address the judge as your honor. Stay calm, never interrupt, and always thank the court. What to expect? Well, this is what happens. The plaintiff usually speaks first. So if you're in a judicial foreclosure and you're trying to defend your house, you're the defendant, the other side goes first. So that's what happens. And then so you'll have your turn. Stay focused on the law and facts, not emotion. Sometimes the judge asks no questions, which is a good sign. If the questions come, they're not attacks, they're openings to clarify your point. So how to structure your statements. We're going to use Christian Kirsch's as an example since he had his oral argument today. You identify yourself, you have your core argument, and your closing. Common mistakes to avoid: rambling or reading too fast, bringing up unrelated issues or new evidence, arguing facts instead of law at the wrong stage. In other words, trying to argue a motion to dismiss when we're not even there. Interrupting the judge or opposing counsel, you don't want to do that. Real world example. We're going to use Christian's since he just went through his. So let's take a look at his oral argument real quick. Okay, this is his oral argument, and I'll read it to you guys the way he read it in court. My name is Christian Kirsch, and I am appearing pro se in this matter. I respectfully ask that the court afford me the consideration that the law provides to self-represented litigants, that is, to liberally construe my pleadings and arguments in good faith. I've done my best to present this case clearly and respectfully, and I ask that the court look past any procedural imperfections in the substantive issues raised here, especially those that go into standing and jurisdiction. I respectfully ask the court to overrule plaintiff's preliminary objections in their entirety. This case raises serious legal defects, and not just with standing and chain of title, but also with the plaintiff's identity itself. Although the caption names the plaintiff as Deutsche Bank as trustee for the Soundview Home Loan 2006 OPT1 Trust, the law firm and filings appear to be made on behalf of PHH Mortgage Corporation, a loan servicer. If PHH is the real party behind this action and not Deutsche Bank, then this court may be dealing with a party who lacks standing and authority to enforce the mortgage and may even lack capacity to invoke the court's jurisdiction. My answer and counterclaims raise these issues directly, and they deserve to be resolved on the merits, not dismissed on a procedural shortcut. Point 1. Lack of standing and real party and interest. Your Honor, standing is not a formality, it's a jurisdictional requirement. Pennsylvania courts have made it clear that standing must exist at the time of filing and cannot be waived, conferred by agreement, or created retroactively. It may even be raised sua sponte by the court. In this case, the plaintiff has never demonstrated that it is the lawful holder of the note. The foreclosure complaint does not include the promissory note in violation of Pennsylvania Rule of Civil Procedure 1147A. There is no evidence of possession, negotiation, or assignment of the note under UCC 3.301. More importantly, the 2011 assignment on which the plaintiff relies is void. That assignment was executed by Tanya Hopkins, an individual widely identified in national mortgage litigation as a known robo-signer. Public records and judicial findings in other cases have shown that Ms. Hopkins signed thousands of mortgage documents without personal knowledge or proper authority. The presence of her signature further undermines the reliability and legal validity of the assignment in this case. It came from Sand Canyon Corporation, which had ceased all mortgage operations by 2008. That is not speculation, but supported by a sworn declaration from Sand Canyon's president, Dale Sugimoto. If Sand Canyon had no interest in 2011, then it had nothing to assign. And if the assignment is void, the plaintiff has no legal interest in this mortgage. Under Pennsylvania Rule of Civil Procedure 2002, every action must be brought by the real party in interest. If the plaintiff isn't that party, then this case cannot proceed. Your Honor, I'm not trying to play a shell game here, but I believe they are. PHH appears to be the one litigating this foreclosure, but they've hidden behind a name of a trust that likely no longer operates. That's not proper under Pennsylvania law. Your Honor, I'm not raising a procedural technicality. I'm stating that the plaintiff never had the legal right to enforce this mortgage. If they receive no valid assignment, they have no enforceable interest and cannot foreclose. That is not a waivable defect, it's jurisdictional. Point 2, trust was incapable of accepting the assignment. Your Honor, the plaintiff claims to act as trustee for the Soundview Home Loan 2006 OPT1 Trust, but the trust filed an SEC Form 15 in 2007, formally suspending its operations and reporting obligations. That means the trust was no longer active and had no capacity to acquire new assets in 2011, which is the year the alleged assignment. So even if Sand Canyon had legal authority to assign the mortgage, which it didn't, the trust could not accept it. A defunct trust cannot acquire or hold new loans. And if the trust cannot hold the asset, then Deutsche Bank, as trustee, had no interest to enforce. That eliminates any basis for standing. It is also important to remember a trustee's legal role is fiduciary, not adversarial. Trustees are expected to act as a neutral custodian of trust assets, not as foreclosing creditors. Bringing a foreclosure action, particularly one based on a questionable assignment, goes beyond the scope of traditional trustee duties, unless clearly authorized. And here there is no evidence the trust had such authority in 2011 because there was no longer a functioning trust to administer. I submitted 2 key exhibits, the SEC Form 15 and a sworn declaration from Sand Canyon's president. The plaintiff never refuted either. These documents show the 2011 assignment is likely void. That's a fact dispute that can't be decided on a preliminary objection. Point 3, estoppel argument fails. Plaintiff argues that I'm somehow stopped from challenging their standing based on a prior settlement or loan modification, but judicial estoppel is a factual defense and is not grounds for dismissal at the pleading stage, especially where material facts are disputed. Most importantly, standing is a jurisdictional issue. It must exist at the time of filing and cannot be waived, created by contract, or cured by borrower conduct. Even if I attempted to modify the loan, that doesn't retroactively give plaintiff legal right to foreclose based on a void assignment. Pennsylvania courts have been clear. Standing must be proven. It may be raised at any time, even by the court itself. Your Honor, even if I once tried to negotiate or settle the debt, that cannot transform a party with no interest into one with standing. A borrower's actions cannot breathe life into a void assignment. If the trust never legally held this mortgage, then no amount of estoppel can fix that. Point 4. My counterclaims are legally sufficient. Your Honor, my counterclaims are properly pleaded with supported by specific factual allegations. Count 1, wrongful foreclosure, based on lack of standing and void assignment from an entity that no longer held any mortgage assets. Count 2, violation of the Pennsylvania Fair Credit Extension Uniformity Act. Plaintiff and its agents initiated this foreclosure without lawful authority, which constitutes a deceptive and unfair act under Pennsylvania Consumer Protection Law. Count 3, violation of the FDCPA. PHH acted as a debt collector and falsely represented its legal right to collect this debt, which is a violation of 15 U.S.C. 1692E and 1692F. Count 4, quiet title, declaratory judgment. I am asking this court to declare the 2011 assignment void and to quiet title to my property. These claims are based on clear factual allegations, including public filings and sworn declarations, and they cannot be resolved without discovery. Closing request. Your Honor, for the reasons I've stated, I respectfully ask this court to, number 1, overrule all of plaintiff's preliminary injunctions, number 2, allow my new matter and counterclaims to proceed, and number 3, let this case move forward so that the facts and legal issues can be fully addressed. I've raised serious questions supported by public records, sworn declarations, and legal precedent about whether they even own this loan. I'm simply asking for a fair process and a chance to prove that the assignment was void and the plaintiff lacks standing, and I've done my best to present this with honesty, research, and respect for the court. Thank you, Your Honor. Okay, so that's how his presentation script was today, and I think he did well. He said that the judge didn't ask a single question, let him speak, didn't interrupt, and at the end said he would have an order within the next couple of days, certainly by the end of this week. So that's good news for Christian. Let's take a look at this assignment of mortgage real quick before we go. As you can see, this is the assignment of mortgage. It's dated in 2011, which again, they didn't have standing in 2011. And it was submitted by the foreclosure mill, McCabe, Weisberg, and Conway, a well-known foreclosure mill. And you can see here it's saying that Sand Canyon, otherwise known as Option 1, and it has an address. It's trying to give it to this trust. And you can see that the second page here, date October 4, 2011. Okay, well, we know Sand Canyon does not exist. Tanya Hopkins, there's that robo-signer. Sand Canyon Corporation, formerly known as Option 1, in 2011, October 4th. Well, let's take a look at Sand Canyon's declaration here. All right, they filed Chapter 13, bankruptcy. As you can see here, declaration of Dale Sugimoto as president of Sand Canyon. And they're saying here that they no longer exist. As of April 30, 2008, they sold the mortgage loan servicing business to American Home Mortgage Servicing. And I mean, I won't read the whole thing because it's really kind of boring if you ask me. But the bottom line is they don't exist. And they went and filed bankruptcy March 18, 2009. You know they don't exist anymore. And it says so right here. It says here, number 5, accordingly, Sand Canyon is no longer engaged in the servicing of residential mortgage loans. Sand Canyon has no servicing rights. Sand Canyon also does not own any residential real estate mortgages. So, I mean, they said this a long time ago, 2008, 2009. So how in the world can this assignment of mortgage that was dated in 2011 be valid, right? Right? Anyway, let's hope the judge agrees with his argument, because standing is one thing that you guys need to argue better to win your foreclosure cases. Okay, so I hope this was informational for you guys. If you have any questions or comments, you can leave them below or send me an email. And as always, everyone have a blessed day.